This recording is copyrighted material. All copyright and other interests in this recording are the property of Brigham Young University. The recording has been licensed to you only for course-related use and may not be edited, modified, or distributed in any form to any other person.
As you know, in FedSoc, we want to facilitate debate, and today I think you're in for a treat. We're going to be speaking about, Miranda rights. So naturally, we have to have Miranda Churkis host our event. So I'm going to turn the time over to her, and you can please give us some introductions.
Hi. Okay, I think I got this. Welcome to our event today. My name is Miranda Churkis, and on behalf of the Federalist Society, I'd like to thank you all for coming to talk about a very important subject to me. Just kidding, it's not really about Miranda Churkis, it's about Miranda rights, about the landmark United States Supreme Court case, Miranda v. Arizona. Today, I'm just going to jump right into introducing our speakers. Our second speaker today is in traffic, but I will go ahead and introduce them both. Our first speaker is Professor Paul Cassell. He is currently a professor of criminal law at the University of Utah. He received both his BA and JD from Stanford University. He then clerked on the D.C. Circuit for then Judge Scalia, and then on the United States Supreme Court for Chief Justice Burger. After his clerking years, he served as an Associate Deputy Attorney General for the Department of Justice, and then as a United States Attorney in the Eastern District of Virginia. After his time out east, he came back to Utah and was a professor at the University of Utah for about a decade before President Bush nominated him to be a judge on the District of Utah in the United States federal courts. In 2007, he returned to the U to continue teaching. We will also have John Mejia today join us, and he is the legal director for the ACLU in Utah. He grew up in Salt Lake City and received his BA from Brown University and then went to the University of Chicago for his JD. In between undergrad and law school, he came back to Utah and worked with Utah Legal Services under an AmeriCorps grant. After law school, he worked at Sidley Austin in Chicago, and then returned to Salt Lake City to clerk on the District of Utah before starting at the ACLU. After both of our speakers today, we will also hear from 1L Chad Carter, who is also from Utah. Chad received his undergraduate degree from Weber State University in criminal justice, and then served on the Utah Highway Patrol for 5 years before pursuing his dreams here in law school. After Chad speaks, he's gonna address both of our speakers and what they said, give his take, and then we'll open it up to questions. So, everyone, Professor Paul Cassell.
Thanks, Miranda. All right. Everybody hear me all right? It's great to be here. As we refer to it, the school down south. Congratulations on a good couple of weekends on the football field. But today we're here to talk about the Miranda decision and how it's showing its age. It's a little over 50 years ago since the Supreme Court decided the decision, and I think we can do better in 2018. So I'm now going to try to give you what takes me about a month to teach students up at the University of Utah College of Law. I understand your quick studies here, so we'll do this in about 1 minute. Historically, confessions have been regulated constitutionally in the United States. You could do that either through the Fifth Amendment to the United States Constitution, which says no one will be compelled to be a witness in any criminal case against themselves. You could also do that under the Due Process Clause, for example, under the 14th Amendment, and say, look, it violates due process of law to introduce into evidence against the defendant a confession that he didn't voluntarily give. If you put a gun to his head or beat him up or something like that, the confession that comes in may be unreliable, and therefore we ought to exclude it. And so for about 180 years or so in this country, that was the law that governed the admissibility of confessions. If it was involuntary, it was excluded. If it was voluntary, it could come into evidence. So now we fast forward to the early to mid-1960s when this fellow, Ernesto Miranda, enters the scene. And a lot of people talk about the Supreme Court decision. Not so many people talk about the crime leading up to it. I think it's undisputed that Miranda used this Packard automobile to abduct an 18-year-old woman. She worked late until midnight in Phoenix, and as she was walking home, he picked her up, forced her into the car, took her out into the desert, and raped her. Later, he voluntarily confessed to the rape. That was the ruling of the Arizona trial court, the Arizona Supreme Court, and ultimately the case goes to the U.S. Supreme Court to see what should happen in these circumstances. And in a 5-4 decision, I think it's probably fair to say this is the most controversial, most famous, most infamous, depending on your point of view, decision of the U.S. Supreme Court, at least in the criminal law area. The Supreme Court reverses the decision of the Arizona courts to allow Miranda's confession into evidence. And here's a quote from the decision. Look, this might not have been an involuntary confession in traditional terms, but our concern for precious Fifth Amendment rights is not, and of course, lessened in the slightest, says the majority of the 5 justices. And if you've watched Law and Order or taken criminal procedure or otherwise have any familiarity with American criminal justice, you've probably seen the Miranda procedures, and here they are set out for you. There are the 4 warnings that must be given to a suspect who's in custody before his statement can be admitted into evidence. And there also needs to be this understanding requirement. The last thing there, if the suspect speaks only Spanish, the warnings would need to be delivered in a manner that he or she can understand, and otherwise determine that the suspect is aware of these rights. Now, a lot of television programs sort of stop there, but there's another part of the Miranda warnings that does not get a lot of attention that I think Chad can talk about and others can talk about. It's the waiver requirement. This is what I call the mother may I rule of police questioning, like the old kids game. The cops have to essentially say, hey, do you agree to be questioned? And if the suspect says no, no questioning is allowed, no matter how reasonable, no matter how restrained. It's only if the suspect says yes, waives his rights, that the questioning can go forward. So when you look at this, I mean, the first thing that occurs to me is, gee, what is the U.S. Supreme Court doing as a matter of constitutional law promulgating these procedures? I think most of us can say, look, this is judicial legislation, and so we could spend all of our time today. I see Mr. Mejia's arrived, and we could spend our day debating, should the Supreme Court be involved in judicial legislation or not. I'm going to take a different tack today. I'm going to just defend what I think is a relatively uncontroversial proposition, that, hey, if the U.S. Supreme Court is going to legislate, it ought to at least be good legislation. So let's just look and see, is this good legislation? Is this, on its merits, a wise policy decision for the United States? And of course, I think immediately the question that you end up with is, what are the effects of the decision? And as early as the day in June 1966 when the decision was handed down, 4 justices were worried about the harmful consequences that this particular decision might have for the country. How serious these consequences would be, only time could tell. But the social costs of crime are extremely serious, and the new ruling will be a hazardous experimentation. So let's take a few moments and look at the empirical evidence on Miranda, and I've been involved in collecting some of that in a series of law review articles. The first bit of evidence that we have on the Miranda decision came in the year or two immediately following the decision, and I've collected all the before and after studies in this article cited here. And so if you look at the first column there, Pittsburgh, about 50% of defendants in custody gave confessions or incriminating statements before Miranda, falls to about 30% afterward. New York City, a bigger drop, Philadelphia, Seaside City, New Haven, so on and so forth. You see pretty much a consistent pattern, drops in confession rates. The one exception is Los Angeles. Enough said, right? It's Los Angeles. But actually, if you drill down into the study there, what you see is the before study is the number of confessions, and the after, which was about 40%. The after study is about the number of total statements, about 50%. I think most people say about half of all statements that are given are incriminating. So if you adjust for that fact, Los Angeles falls into line. So you have a pretty consistent picture here. 15% decline in confession rates after Miranda. But people looked at that article and they said, Professor Cassell, okay, that might have been the case in 67, 68, but cops have learned to work with Miranda. And if you walked into any major city in this country, you'd discover that, people like Chad, they know the tricks of the trade, they know how to get confessions out of people. So that's an empirical proposition. Somebody's saying, what the facts are, but nobody had actually gathered the facts. And so in 1994, I went into my local prosecutor's office, the Salt Lake District Attorney's office, and said, all right, let's collect some data. And over the summer with a couple of research assistants, we collected evidence on what percent of suspects had confessed in the cases that were moving forward, the serious criminal cases moving forward through the screening process in the Salt Lake DA's office. We found that, maybe a third of suspects confessed, maybe something like 15% invoked. A number of other suspects were not questioned, possibly because of the Miranda warnings, and so that was the finding that we had in 1994. So people said, well, wait a minute, okay, that's Salt Lake City. They don't drink coffee out there. I'll bet that's not applicable, for the national average. So why don't you give us some national data and show us what would be the case for across the country? And that's sort of like the challenge that the Wizard of Oz gave to Dorothy, right? Bring the broomstick back. Oh, there's no broomstick out there. There are no national studies on confession rates. So when people were saying, Professor Cassell, give us national data on confession rates, I think they knew what the answer would be. There is no such data. But is there a surrogate measure? Do we have a measure of law enforcement effectiveness in the United States that would tell us whether or not there had been a change after Miranda? And many people, the American Bar Association, Steve Schulhofer at the University of Chicago, Yale Campus Art at Michigan, had cited clearance rates as a measure of Miranda. They said, maybe they went down a little bit, but they went back up after Miranda and everything's hunky-dory. Well, people had made that assertion, but no one had ever actually looked at the confession rate data. And I still remember going to the basement over at the law library at the University of Utah and pulling out the data. And here's the data on this, by the way. This is not Paul Cassell data. This is FBI data. This is the Uniform Crime Report data from around the country. And what you see here, if you look at this starting in 1950, 65% of violent crimes in America were cleared or colloquially solved. This is how many were solved. Kind of bounces around in the 60s. 1965, about 60% of all violent crimes in America were cleared or solved. And now we have, that's the last pre-Miranda year, 1966, halfway through the year, the cops have to comply with the Miranda warnings. 67 is the first year in which the entire American law enforcement year was spent operating under the Miranda regime. And I think most commentators that have looked at the issue have said it took about a year or two for Miranda to become operationalized in law enforcement operations around the United States. And so you see this very significant drop to about 60% cleared before, 45% cleared after, and the thing has remained essentially the same ever since. In fact, you can extend the data on to 2012. And so what you see is, again, contrary to what defenders of Miranda had said, a very significant decline in law enforcement effectiveness in America at exactly the time of the Miranda decision. So when that fact came out, the defenders of Miranda said, oh, wait a minute, you need to control for other things. Crime rates are going up, and the baby boom kids, they're entering their crime-prone years at around the time of Miranda. There were inflation rates going on that was meant that fewer dollars were being spent on law enforcement. And again, these are factual propositions. These are claims that can be tested. And the usual way for testing that is with multiple regression analysis. And so with a colleague of mine at the University of Utah, Professor Richard Fowles in the economics department, we went around and collected data on all the things that people suggested had been responsible for this reduction. And what we discovered was even controlling for those, there is a significant reduction in crime clearance rates that is attributable to a structural change in the clearance range function at exactly the time of Miranda. Controlling for crime rates, police personnel, police dollars, baby boom kids, law enforcement participation, unemployment rates, different things like that. None of those can explain away. Maybe they can explain away some of the change, but at least half of the change remains attributable to a structural change in law enforcement effectiveness at the time of the decision. Now, of course, to prove causation, you would probably need more than just some statistical artifact. So is it logical to think that Miranda caused this reduction in law enforcement effectiveness? Well, remember, this is the single most significant decision handed down by the United States Supreme Court regulating law enforcement investigations. I think that's generally accepted, and I'm defending what I think is a very modest proposition that, hey, when the Supreme Court significantly changed the rules governing police investigation, that had some effect. And indeed, that's consistent with what law enforcement officers at the time were reporting. Chad's a little bit younger than having been around in 1966, but if you talk to cops back then, they said, yeah, this made it a lot harder for us to get confessions out of suspects. You'll notice, by the way, that We have a period of 66 to 68 where the drop occurred. Most people saying it took about a year or two for law enforcement to come up to speed with Miranda. And another thing, if you drill into our regression equations, what we found was not uniform drops in crime clearance rates, but we found this in particular crime categories, specifically robbery, larceny, vehicle theft, and not for other one-time crime categories like, say, murder or something like that. This would be consistent with the idea that professional criminals, repeat players, those who know how to lawyer up and take advantage of the Miranda rules would be the ones who are not confessing. We also found that this was a national phenomenon. We collected data, but we were able to break it down into different city sizes, large cities, medium-sized cities, small-sized cities, and we saw this reduction spread across all population subsets, which would be consistent with the national phenomenon rather than some, major affected big cities or small cities. Now, the last thing is, and maybe this will be something that we'll be debating here later on today, I think we might hear from the ACLU that, oh yeah, of course there were fewer confessions because cops stopped beating people up in 1966, so we should be applauding this result, not criticizing it. And again, let's be clear, that's a factual proposition. That's an argument that, let's say, 9% of confessions or cases that were being solved in 1965 were being solved because cops were beating people up. And then 2 years later, they weren't doing that. Okay, what's the evidence to support that? You first would have to show that there were a lot of people being beaten up to get confessions in 1965. A statistically significant number. I'm not foolish. I don't think there was never a bad cop in the South that beat somebody up to get a confession, but I'm going to defend the limited empirical point today. That was not sufficiently widespread to cause a dramatic change in crime clearance rates in 1966. And don't take my word for it. I'll offer some evidence here. I'll offer President Johnson's commission on the Law Enforcement and Administration of Justice. And in February 1967, having collected data that was pre-Miranda, they said, look, today the third degree is almost non-existent and coercion to obtain confessions has been virtually abandoned. So that's why I don't think you can attribute this big drop to a change in coercion, because as of June 1966, it was essentially non-existent. But maybe you don't believe me on that, or maybe you have some concerns about this. Let me give you a second point to consider. Suppose you're worried about a cop with a rubber hose that's going to beat a confession out of you. That was illegal in 1965. That was against the rules. That could have led to discipline or sanctions for most law enforcement officers. And now Miranda says, oh, by the way, you're supposed to read these few words off a card. Do you really think the cop with the rubber hose is going to say, oh, well, now I'm supposed to read this card, I'm going to abandon these unconstitutional tactics? I just think the argument that these changes in law enforcement effectiveness can be attributed to coercion simply don't hold up, again, as a factual matter. So we're left then with this problem. I think Miranda is perverse public policy. Miranda divides suspects into two groups, those who waive their rights and those who don't. Remember, that's the Mother May I rule. So let's talk for a moment about those who waive their rights. Who are those who waive their rights? If you're innocent, hey, I want to waive my rights. Let me tell you got the wrong guy here. And then maybe that person ends up giving a false confession. What if somebody is mentally disabled, has difficulty understanding Miranda warnings, or accedes to authority figures, as many disabled people do? Those are going to be the people who waive their rights. And once they waive their rights, what does Miranda do? Nothing. The old voluntariness rules remain in place, but Miranda doesn't offer any additional protection. So that's one category. What about the other category? For those who refuse to waive their rights, hey, I got a lawyer, I'm not saying anything. Who are those people? Those are the professional criminals. Those are people who have lawyers on retainer, wealthy people. Those are exactly the people that we don't want to benefit. And so what have we done here with the Miranda regime when we create, as a matter of public policy, a new way of regulating police protection or police interrogation? We benefit precisely those people we don't want to benefit while doing nothing for the innocent. So the conclusion here is that Miranda perversely underprotects the innocent and overprotects the guilty. So from this, I reached the conclusion that it's time to reform Miranda. There is significant evidence that excluding confessions and restricting law enforcement is harmful public policy. You know, if you want one example of that, former professor, now Justice Tom Lee of the Utah Supreme Court has talked about, in the Fourth Amendment context, it's suppressing evidence is to suppress truth and let criminals free in the community without punishment. With respect to Miranda in particular, I know this is a little hard for people in the back row to read, but our regression equations show that about 213,000 violent crimes each year are not solved because of Miranda, and about 929,000 property crimes are not solved or cleared because of Miranda. Those are significant costs. And by the way, who bears those costs? Who are the victims of these crimes? We know that they're disproportionately going to be racial minorities, residents of inner cities, the poor, and others who are in the worst position to protect themselves against criminal deprivation. Again, perverse public policy. So can we do things differently? Miranda itself said, look, we're legislating, I guess they didn't admit that, but we're coming up with this set of rules, but we're not creating a straitjacket. We encourage Congress and the states to think about other ways of protecting rights. And the Utah Supreme Court has essentially said the same thing, that there's no requirement under Utah law to have the Miranda warnings. Now, back in 2000, I was appointed by Chief Justice Rehnquist to argue the Dickerson case. I tried to argue there that there was already in place a set of alternatives that meant Miranda had been overruled. 7 justices disagreed, but 2 very wise and wonderful justices, Scalia and Thomas, saw the wisdom in that position. But that's the law of the land. So what do we look like in 2018? I just have an article, if you're interested in more on this, just came out a couple of days ago in the Utah Bar Journal. But basically I say, look, let's not think that the rules that were adopted by a narrow majority, 5-4 majority, by the Warren Court back in 1950 are the best ways of regulating police interrogation. How might we do that? Let's give some modified warnings, tell people they have the right to remain silent, but let's get rid of the waiver requirement. And what kind of protection should we put in place? Let's videotape the interrogation. If you're an innocent person worried about a rubber hose, would you rather live in a world where the cop's supposed to read a few words off a card, or there's a video camera running to see what's going on? If you're an innocent person or a mentally disabled person that's worried that your words are going to be twisted around, again, do you want to live in the world of Miranda, where you're supposed to understand the Miranda regime and invoke your rights and things like that? Or do you want to live in a world where the video camera records exactly what's going on? I submit to you that the choice is clear. And indeed, in Utah, we are now moving in the direction of videotaping interrogations. So I think it's come time to reform Miranda, to rely on things like videotaping to protect suspects, rather than the regime that Earl Warren and his colleagues created back in 1966. I look forward to hearing what others have to say about this, and to hearing what you have to say about this as well.
Well, maybe put that back on. Sorry. So just starting at the point of, by the way, I'm John Meehan, the legal director. I guess I was introduced in absentia. Whatever they said about me is probably true. And I apologize for being late. There was an accident. But so I guess I'll start where Professor Cassell started, which is, if we're looking at the problem of Miranda as like the court making additional rules, and maybe I guess you could say the equivalent of the law, what problem was Miranda trying to solve? Miranda was not trying to solve the problem of there being too few criminal convictions in the United States. Miranda was trying to solve the problem of coercive confessions. And Miranda was specifically looking at the Fifth Amendment right to not be compelled to testify against yourself at a trial. And the decision was made, it has been decided that when the state is trying to interrogate you while you are in the state's custody, while you are in police custody, that is an inherently coercive situation. It doesn't require a fire hose. It doesn't require dogs. It doesn't require the literal third degree. It is a moment where you as an individual are being accused by your state or your federal government of a crime, and they are seeking to take away your liberty. They're seeking to take the entire mechanism of the prosecution of the state against you, the individual person. There's a clear power and difference there. So the question that the court is not that was before the court in Miranda was, how do we give this person who is now facing the state, now facing the inherent coercion of being handcuffed, taken into a police department, put into a room, told you're going to be told you're going to have to answer questions about a suspected crime. Okay, that's what Miranda's about. It's not about solving crimes. It's about protecting the individual against the coercive power of the state, given the fact that we have protections in the Constitution that the state may not coerce you. So, as you know, if you look at the bar journal, Professor Peoria responded, and he pointed out that Justice Warren used to be a prosecutor, so he was familiar with the tactics of police, and he wasn't. So he understood that what happened when police were questioning criminal suspects, and understood that to be coercive, understood that to be when you were actually arrested and put into custody, a coercive situation just on its own. It did not require fire hose, it didn't require dogs. The question of videotaping as a replacement for that, I don't have a problem using videotaping as a tool to help prevent coercion. There's no problem. I don't think I have a problem with completely replacing the prophylactic help, or the purpose of Miranda, the purpose of the warning, is to protect that right, so that you as the person know, okay, I'm in a very tense situation, I have this cop who's saying I did something. Maybe you do or you don't know about your right to remain silent. I don't think having a videotape is going to make you know that you're being silent, because what Miranda said, Miranda does say, Miranda says, yes, this is not meant to be, this decision is not meant to be to stop the state and local governments from figuring out another way to help these people to prevent the situation. Right now, the way we're going to do it is require them to warn you that you have the right to remain silent. Come up with other ways. Well, I don't think that, and they say come up with other ways to make sure that the person knows that they can remain silent in this very fraught, tense, coercive situation. Having a videotape helps, but having a videotape alone does not help the criminal suspect understand that he or she has the right to remain silent. That's the question that Miranda is answering. I don't have a problem with videotaping, but I would emphasize that there are many videotaped false confessions. Videotaping does not necessarily prevent false confessions. The Central Park Five, I believe, were videotaped confessing. And, if you don't know who the Central Park Five are, those 5 boys who, there was a very heinous crime in Central Park in New York in the 80s, and the police went and rounded up 5 black and brown boys and brought them into the station, and after hours and days of coercive interrogation, had a videotaped confession of them saying that they had done this. None of them had actually done it. They spent decades in prison. Somebody who's currently the President of the United States took out a full-page ad in the newspaper saying they should have given the death penalty at the time. None of them had done it. And even when they got out, people were still saying, well, they must have done something. They were in prison. They were wilding, So the idea that a confession is going to prevent false confessions, I think, is maybe in some cases, but not in all cases. The clearance rate. So I owe this to Professor Alschuler, who I had for Crim Law 1, 2, and 3 at the University of Chicago. And Professor Alschuler wrote a paper that looked at Professor Cassell and Professor Fowles' study and talked about the clearance rate. So what Professor Alschuler says is it's not really accurate to look at the clearance rate when you're talking about Miranda, because what the clearance rate is, that's all of the local law enforcement agencies in the country aggregate their data and give it to the FBI, and that's the national clearance rate. So a crime is considered cleared when you arrest somebody for that crime. To arrest somebody for a crime, you need to have probable cause that they committed that crime, meaning that the person that they arrested was a suspect in that crime regardless of what their confession is or isn't afterwards. So they've cleared the crime because they've arrested somebody, and now, if they have probable cause and they're arrested, they should give them Miranda. But that would only affect the clearance rate to additional crimes in addition to the one that they got arrested for. Because the clearance rate is that you're already cleared once you're arrested. It doesn't necessarily mean that there was a criminal conviction from what Professor Altshuler says about the clearance rate. So there is a lot of skepticism about using the clearance rate to say anything about whether Miranda affects it, because the crime is cleared once you're arrested. You have probable cause. Now, there's something called the secondary clearance rate, which is when somebody gets arrested for something and then starts talking about other crimes that they committed that were unsolved, then you're secondarily clearing those crimes as part of that investigation. But there's questions about the reliability of using secondary clearances when you're already arrested, trying not to go to jail for too long. So, you know, if you've, like, let's say the Home Alone robbers, right? They're the ones that, you know, they flooded the houses that they robbed as part of their little signature. And so the Home Alone robbers are you know, they'll confess to Macaulay Culkin or whatever, I forget, Kevin. They'll confess to Kevin, and then they'll say, okay, if you confess to these other ones and we can clear those from our unsolved crimes, we can look better and you'll get less time. So there's reason to think that maybe that secondary clearance rate is also somewhat suspect. So, you know, I think that I would be reluctant to rely on clearance rate data as saying anything reliable about how Miranda is handcuffing cops or not. Because if the police are following Miranda, they should already have some reason to suspect that person committed the crime when they initially arrested them. Also on the hundreds of thousands of crimes, let's see, maybe I can use this. Maybe not.
Use the arrow, sorry, on the computer.
On the computer. Is this 1 year?
This is annual data, yeah.
So, I mean, and this is based on just like the idea that from the clearance rate that 20 additional. I mean, I think the problem with relying on this particular number is for those 213,000, do we know whether, for the violent crimes, do we know whether there was a suspect in custody who invoked Miranda? Were there 213,000 people that there were probable cause to believe that they committed a crime and so they got arrested and were questioned about that crime? Do we know that in those 213,000 cases, was there a suspect? Unless we have that information, I would urge caution in trusting this kind of number. Property crime, 929,000, nearly 1 million. Did they have 929,000 people in custody that invoked Miranda? Or is this just based on sort of statistical analysis? Because, you know, I've had my car broken into before, several times. I don't think Miranda is what stopped those people from getting caught. It's the fact that the police just don't have time to track down. I mean, it's a tragedy for me, but the police don't have time to track down those 929,000 people who broke into your car. So, larceny, vehicle theft, I mean, so rely on these numbers as something that Miranda caused, you would have to know how many of these crimes actually had a suspect that was arrested that invoked Miranda. And the arrest was not, you know, they had probable cause to believe they committed the crime, but it was just that lousy Miranda invocation that stopped it. So I'm a little skeptical of these numbers. And I also have a problem with the statement that people who know their rights and invoke their rights are not the kind of people who should benefit from the Fifth Amendment. I find that to be kind of a problematic statement. I mean, yes, wealthier people have, you know, can consult attorneys, but I don't think it's fair to say that a wealthy person who consults their attorney shouldn't be protected by the Fifth Amendment just like anybody else, or a poor person who watches a lot of Law and Order and knows to call their attorney. And that doesn't imply guilt. The fact that you know your rights and can invoke them, I don't think it's fair to say that that is an implication that you know, or that you're guilty. I mean, it may be that professional criminals or people who commit crime are more, because they've been through the system and they know the tricks and they know their rights, it may be fair to say that they could be more likely to invoke their rights, but I don't think it's fair to say that as a general statement. So, I mean, I think that I agree with the majority in Miranda that says perhaps there will be some convictions that we lose because of this protection of the Fifth Amendment. But what we're talking about is preventing the state from coercing people. And until we have a better rule than Miranda, and I don't think videotaping gets us there. I think Miranda still has a lot of vitality, and as recently as 2000, there was a pretty robust agreement of that by the Supreme Court. Thanks.
Hello. I have not done research or studied this extensively, but I do have some real-world experience, and I think that's why I'm here today. I don't really fall down on either side of this debate. I don't really have an opinion about whether or not we should keep Miranda or reform it, but I do have some personal experience, like I said, that might contribute to the discussion. So, for some background, I did work for the Utah Highway Patrol for the last 5 years. I just quit last month to come here to law school. During those 5 years, I arrested approximately 200 people for various offenses. If I didn't say this already, I was working in Salt Lake County. So I worked directly with some of the biggest police agencies that we have in this state, including every municipal police agency in Salt Lake County, as well as the County Sheriff's Office and other state police agencies as well. Getting back to my 200 arrests, Miranda, I think, is kind of I'm going to call it a high-risk, low-frequency occurrence in felonies, really dangerous and violent crimes. But from my experience in dealing with crime, I'm going to just let it be known right now that I had a very kind of limited view of the entire crime picture. So as you can imagine, violent crimes such as murder, rape, and those kind of things are a big deal. They're a much bigger deal than small things like speeding, but they occur much less frequently. And so the real world application that I saw as a police officer for 5 years mostly consisted of misdemeanor crimes, and any felonies that I had were, I'm going to say, non-violent probably. So with kind of that background to go on, I'm just going to talk about a few interesting points that I saw in my career, and maybe some things that you might not have thought about, or just kind of interesting points of view that go beyond just the theory of Miranda. So, just from my own personal experience, I only saw maybe 1/4 to 1/3 of people actually invoke Miranda rights after they were read. And usually when people did invoke Miranda rights, it was done before we actually recited them to them. So my point there is people that know their rights generally will tell a police officer that they don't want to talk or that they want an attorney before the police officer even has a chance to tell them the Miranda warning. People that know their rights invoke them early. I would say that the majority of people, even after reciting Miranda, decided to talk anyway, in my own experience. This is just my own very personal belief. I just feel like the Miranda warning has kind of lost its meaning in our culture. I imagine that at the time that the decision was made, the very first police officer that told a suspect that he had these rights, he probably listened. He probably listened very closely and thought about what the police officer was saying. But how many of you, when you were 5 years old, probably could have recited your Miranda rights to your mom, right? Like, when you get arrested, they read Miranda rights. And I don't think people, in my experience, actually listen to what the rights are. You have a right to remain silent. Today means, crap, I'm going to jail. Along with that, too, just as a note, Miranda is not normally read at the time of arrest. A lot of you that have taken kind of criminal law and criminal procedure probably know that already. But it's only required when a suspect is in custody and being questioned as well. Further along, kind of like a practical application, I never in my 5 years saw a defense attorney brought in to an interview or interrogation, ever. I've never seen that happen. The only times when I can imagine that would happen is in a murder case. Generally, if a person invokes their rights, the police are just going to stop asking questions. They're not actually going to get an attorney and bring them into the room to be there. And I guess just my last little point of interest is, obviously I've only worked as a police officer since the decision was made, but I've never seen an officer that used shady tactics or tried to coerce people after they invoked their rights. Every single time I saw someone say, I don't want to talk, or I want a lawyer, I never saw a police officer go further than that and try to pressure them into making statements. So my point there is that police officers have been following this rule. But again, as I've stated, I think it's kind of lost the original meaning that it had, and most people know about their rights, whether they're told them or not, just because of pop culture and social media.
Well, thanks, John, and thanks, Chad, for those comments. Just a few quick responses, and then I think we have time for questions from everyone. John mentioned the problem of inherent coerciveness, so I think it's fair to ask, well, how well did Miranda do in responding to that problem? That's the point I was trying to make. If it's going to be judicial legislation, is it good or bad? Well, we just heard from Chad that in his experience, about 2/3 to 3/4 of all suspects waive their Miranda rights, and I think that was his experience generally consistent with the data I was presenting here today. So for 2/3 to 3/4 of suspects, Miranda is irrelevant. It does nothing to solve the problem of inherent coerciveness. But what about the other fraction, the 25% to 33% that invoke? Who were those people? And again, I think Chad's experience was exactly in line with what I was suggesting to you. These were people who invoked before the cops even gave them the warning. Those are the professional criminals, the people who have been arrested before, people who have lawyers on retainer, and otherwise people that are frankly least deserving of protection. And it was interesting to hear Mr. Mejia talk about what about the Central Park jogger defendants? What about them? I guess I would throw the question back to you. That happened in the world of Miranda. Why isn't that an indictment of the current system rather than the changes I'm proposing to make? And by the way, how were those people ultimately exonerated? Through the videotape. They were able to show that the cops had essentially talked them into committing crimes that they hadn't committed. And unfortunately, not every defendant nowadays has the videotape regime, which is my proposal. We have to rely on the ACLU-style Miranda warnings, which, as was pointed out even by my opponents here today, leads to innocent people being convicted. And what about the numbers? We could go into some of the details of the numbers. I think what I'll just do is I'll just go. We heard from Professor Al Schuler was quoted as saying, hey, look at some of the data here. But the one thing we didn't hear was what was the title of that article. The title of the article was Miranda's Fourfold Failure. And I read the conclusion of the article, and the print's a little small here, but this is how the conclusion begins. 50 years experience has confirmed the fourfold failure of the fourfold Miranda warnings. I'm down with that. Let's see. Miranda is a doctrinal failure. Oh, yeah, it doesn't link into anything that had existed in American doctrine before. Miranda is an ethical failure. It benefits professional criminals and not others. Miranda is a jurisprudential failure. The subsequent decisions of Miranda are internally inconsistent. And it's an empirical failure that has not provided the protection that Earl Warren and others hope. So don't take my word for it. Take the professor that's being cited by my opponent. By the way, what does Professor Al Schuler propose? He doesn't propose videotaping. He proposes that magistrates should interrogate everybody after they're arrested. And I would be perfectly open to that kind of an alternative as well. But one thing I think we need to do, though, and perhaps we can all come together on this, is to say Miranda is a fourfold failure. It's a failure in every way, and it's time that we reform it. I look forward to having questions from the audience as well.
It's always really hard to be told that you're a fourfold failure. But I think I'll be okay. But thank you so much to our speakers today and to If you have class at 1 o'clock, please feel free to get up and leave. But we would like to take questions for our speakers now. Thank you. Go for it.
So maybe I just have a very limited perspective on this, but clear crimes aren't nearly as important to me as correct convictions and the number of incorrect convictions. Do we see any data, or are you aware of any data that suggests that after Miranda there were increases in guilty people who were acquitted or innocent people who were convicted?
So I have a new article coming out in the Arizona State Law Review that says that the number of wrongful convictions of factually innocent persons is approximately 0.026%. So the number of wrongful convictions is so minuscule that it wouldn't show up in, I think, the aggregate national data one way or the other. By the way, if it did, Miranda is going to have, I think, essentially no effect on wrongful convictions. Again, that's the perverse public policy point. The innocent people are going to waive, so they get no protection at all under Miranda. And I applaud your concern about people being wrongfully convicted. You should vote for my proposal rather than the ACLU-style proposal. Their proposal, that is the Miranda regime, is a fourfold failure that does nothing for innocent people. My proposal would do something for innocent people.
I don't think that being informed of your rights does nothing for innocent people. I think that is not correct. I mean, Al Schuler has a broader, obviously, disdain of Miranda, which is fine, but it's not because he doesn't disdain Miranda because it results in fewer convictions. He does not like Miranda because it leads to lots of chicanery by police. I mean, I would encourage you to read that article. This is not sort of like Miranda is such a horrible fourfold failure because it leads to fewer clearances. Miranda to him is a failure because it leads to a regime where police are sort of bullying people in different ways than sort of the outright stuff that was happening pre-Miranda. So, I mean, I think Al Schuler has a different sort of worldview on that. I'm not aware of studies. I know that there are wrongful convictions. A lot of them are cleared by DNA. The Central Park Five were not cleared by their videotape confessions. Those were what convicted them. They were cleared by a later confession by somebody else, and then the DNA evidence proved that he was actually the one that had done it. So it was not the videotapes. The videotapes sunk them. I mean, I think later, when they were working on their innocence, or proving their innocence and showing that they were able to show, hey, this videotape confession that got me into jail in the first place, when I was a 16-year-old kid or 17-year-old kid, in retrospect, that looked horrible. When it was happening, that got them sent to prison.
Thank you.
Yeah, so most people can agree that Miranda hasn't done quite enough or could be improved upon. But the Supreme Court has repeatedly said it's still in our best interest to inform people of their rights, whether they're going to invoke it or not, etc. Why can't we just accept that Miranda should stay and we could additionally do more to get the effects that we want?
I agree. And there are about 1 million reasons for that. 213,000 violent crimes and 900,000 property crimes that are unsolved each year under the Miranda. So those are social costs. And again, I hope, I'm particularly concerned about the distributional aspects of those costs. I'm going to drive home to a nice, safe community tonight, but there are many Americans who will drive home to very dangerous communities. Those are, for example, people who live on the south and west sides of Chicago, where about 500 people a year are killed and 2,000 people a year are shot. So I think that's why we need to think very seriously about how can we improve law enforcement in America so that all Americans live in safe communities.
Another question? So it seems to me that one thing that wasn't directly cross-addressed was the sort of the last part of the Miranda rights, which are you've been read your rights, which as an innocent person who could get arrested, I would want to be read my rights. But there's this last part, which is this question that says, can we ask you questions? And so my thought, and that I didn't think got directly cross-addressed. So like, could it be possible, I mean, from your perspective, could it be possible to read someone their Miranda rights and would still be relatively, would that be enough without specifically saying, now, can I ask you questions, as opposed to simply asking questions that the person can always knows that they can say no. Like if you tell someone you can say no to any question, you can refuse the answer, but still asking those questions.
I mean, as I understand it, a knowing and voluntary waiver of any right is possible. But that's the problem with. I mean, I guess that's the way I would answer it. If you have a knowing, intelligent, voluntary waiver of your rights, we recognize that. And so if it's a non-coercive, if you then are in court in custody, you can't answer questions, and you can stop whenever you want to. But I mean, I just sort of also addressing something else. When we say that, I think it's very treacherous to say that there is a group of people that we think are less deserving of rights. That if somebody we would consider a professional criminal or somebody who knows their rights is somehow less deserving. Everybody retains their rights all the way through. Constitutional rights, due process, are there to protect the innocent and the guilty. So if we start this analysis that begins with certain people are less deserving of rights, that becomes very problematic from my perspective. That doesn't directly go to your question, but just that's it.
And by the way, just one quick follow-up. What would the world look like if the cops just gave warnings and then dove right into asking questions without asking for a waiver? Well, there'd be double-decker red buses driving around and guys in funny hats and things like that. That's what they do in England, and as far as I can tell, it's a perfectly free and democratic society. So the kind of proposal that I'm making is something that works in other parts of the world.
Should we take more questions?
Yes, last one. Take Matt's question.
Okay, Matt.
Oh, people want to hear from me. He just left, darn it. I'm a former police officer as well. And my experience has been very different from his. And I just want to say something because I worked on the Arizona-Mexico border for 3.5 years before coming to law school. And I dealt a lot with gangs and with immigrants and with people who don't speak English. And so for me, the Miranda warnings were a very big part of the investigation because what we found is if you didn't speak English, you did not know what your rights were. And that just generally was how it was. And I understand that my experience is anecdotal, may not be statistically significant as far as the national average goes. But we also didn't really see, and again, my personal experience, we didn't really see any negative from informing of Miranda rights. I found if people are going to talk, they're going to talk. And if they're not going to talk, they're not going to talk. And informing them of their rights didn't feel like a roadblock. And so I guess for my question, and half the time when you read the Miranda card, people don't know what you're saying anyway. Like they don't understand. And you have to explain it to them over and over again because they'll hear it and they think, oh, well, okay, I want my attorney now. And you have to be like, no, I'm not questioning you now. You don't have to have an attorney now. If you want, I can give you an opportunity to look for one. And then they never find one, and then they never get an attorney, and we ask if they want one appointed, and they give up by then. So, I mean, to me, it's a completely different world. I don't think the purpose of the Miranda warnings has died out. But I guess my question is, I haven't seen, in the presentation so far, I've seen like maybe a correlation with data that might suggest that the Miranda warnings aren't effective. But I haven't seen anything that really shows the negative effect. And I don't know if you could expect, because I understand the data, you said, well, we're not solving as many crimes. but it seems really correlated to me, and it doesn't show much causation. Do we have, or is there any information that might show a causal effect between Miranda warnings other than the date that these numbers declined Miranda? Do you understand my question?
I do. And I have a 120-page article in the Boston University Law Review that essentially presents, what we presented in a truncated fashion here today.
Right.
There is that drop after Miranda. So it's and the multiple regression equations can, I think, exclude other possibilities, such as rising crime rates or baby boom kids as the cause of that. But you're right, it still is the question, what caused crime clearance rates to fall? And I have 20 pages explaining, look, the blindingly obvious cause is Miranda. Let's remember the proposition I'm defending. When the most significant and controversial United States Supreme Court decision regulating police interrogations came down, completely changing the rules of police investigations, there was a real-world effect to that. A 9% drop in violent crime clearance rates. I mean, I'm happy, and in this article I try to go through, if it's not Miranda, what was it, the British rock invasion? The Beatles became, I'm making fun, but nobody has given me, and if somebody wants to give me an empirically testable alternative causation, we'll test it. But there isn't, it's been 20 years since my first paper came out. Nobody has given us any other empirically testable proposition to explain why crime clearance rates fell after 1966. In fact, originally they said, look at California data, and California didn't change, so your theory's wrong. So we go and collect California data, and we show, no, actually, crime clearance rates went down in California. They said, but this is just a big city problem because there were riots in big cities. So I go and get data in rural areas. In rural areas in America, crime clearance rates fell after 1966. So at some point, you can tell I'm a little frustrated because people keep throwing something, hoping it'll stick on the wall, and we keep swatting it down, and still people say, it must be something else. No, it's not something else. It's obvious. It's Miranda that caused the cops to be able to solve fewer crime after 1966, and we're still living with those consequences today.
If you look at the fourfold failure article, there is, and I didn't read it, so I can't say what, but there is a suggestion by other authors that it was the changes in the way that the local law enforcement were reporting clearances to the FBI, so that there were different practices that, and I'm sure he obviously knows a lot more than this than I do, but I'm just describing, touching the surface of what there was a study that suggested some different reporting practices.
But personally, I don't see Miranda as a huge impediment. I'm not sure it's effective, but I don't think it's an impediment either. But I'm definitely going to check into both of those articles because it's something interesting. Anyway, thank you.